I should be good, right?
Yes.
All right, I just let someone else. All right. Okay. Good morning, everybody. And on behalf of the French American Chamber of Commerce of Chicago, thank you for joining us this morning. We are we're still waiting for a few more people who will trickle in as we start, but we didn't want to make anybody wait too much longer. Out of and try to make sure that we can wrap up on time. We are just a couple notes of logistical notes. We are recording this session. The recording will be sent to everybody who registered for this webinar after the webinar, with the speaker's presentation and all of her contact information, so you can follow up with questions. The recording will also be on our website by today or tomorrow morning. We ask that you please, for the duration of the presentation, stay on mute and keep your video off. And we will open it up for questions at the end of the presentation. Feel free to turn your video back on. We'll close the presentation so that we can have more of a conversation and you can just ask your questions directly. So thank you very much and welcome to Samera Ludwig, from a partner of L&G Law Group. And she is going to talk to us today about a very important topic over the next few months of how we get back to work. So back to the office, workplace compliance issues and guidelines for employers. Samera, I'm turning it over to you. Thank you very much.
Thanks, Andrea. Welcome, everyone. I hope you can hear me all right. As Andrea said, I am a partner at L&G Law Group. I practice employment law and immigration law. And we've put together this presentation because it's fairly timely given that people are headed back to work. It's fairly comprehensive as I go through this. I've flagged many issues. Indeed, I was telling Andrea that some of these specific topics we could spend an hour on individually. So I've done this more as an issue spotting and cover certain ones that I think are important and significant in greater detail. I'm sure, I wish we could take a poll. I mean, there's only 3 of us, but if for example, I'm at the office right now, we are under a voluntary coming into the office schedule. You can still telework if you can. If you want to come in, you can. But a lot of businesses I've heard are resuming operations, half capacity, or they're letting people decide if they want to come in and setting a date further on down the road. Typically, as I've heard just from an anecdotal poll, a lot of businesses are scheduling mandatory attendance after Labor Day. Okay. So I just thought I'd give just a current status on COVID-19. We all know that it's a respiratory illness that spreads from person to person. The World Health Organization declared it a pandemic on March 11th, 2020. I put that date out there just to show what a short time, in just a short amount of time, these are the statistics. This is as of yesterday. We have 11.6 million confirmed cases and 539 deaths in the worldwide. That's the worldwide number. The 3,139,000 deaths are for the U.S. And then Illinois has 147 deaths, and they are rising. A lot is still unknown about this virus. That's why the guidance in the past few months has been changing. If you're like me and have been on the Illinois Department of Public Health websites or the CDC's websites, they were literally changing guidance, sometimes several times a week. So the current status in Illinois, the most recent executive orders that were entered in by Governor Pritzker were on June 26th. Executive Order 2020-43 is actually the one that put us in phase 4 under the Illinois' Restore Illinois plan. And then Executive Order 2020-44 is something that was done in conjunction with 43, and it reissued basically most of the prior orders, extending the deadlines by another month to July 26th. It amended prior orders so that, for example, in-persons teaching at schools for summer schools is okay now. And then also on this date, Governor Pritzker renewed the disaster proclamation, and that just allows, it facilitates aid, coordinating aid and getting financial aid from the federal government to Illinois. This is directly from Executive Order 43, and I thought it was worthwhile to put it in a screen for everybody to see, because people, I mean, most people don't read the executive order. They read news articles or summaries of it afterwards. But this is actually the language from the order that says that there are public health requirements for businesses that include nonprofits, that you must take the following public health measures to protect their employees and customers and anybody who comes in physical contact. What do you have to do? You have to evaluate and encourage remote work when possible. You have to ensure that employees practice social distancing and wear face coverings, and ensure that all spaces where employees may gather allow for social distancing. So for example, employees may gather in break rooms or lunch rooms. You need to make sure that those permit safe distancing. Some employers have removed break rooms altogether and have just sort of shut that down. Some employers have installed plexiglass if you have tables and chairs for employees to eat. And some people have kept it open but have removed seating. So those are, but it's basically ensuring that if there are areas where employees gather, you need to make sure that the physical distancing requirements are met. And of course, you have to ensure that all visitors practice social distancing. So if you have people coming into your workplace, for example, customers or vendors, clients, and if it's not possible to keep the 6 feet distance, then you have to mandate the face covering. I know a lot of employers are basically currently saying no visitors allowed. That's also a way to go to ensure that visitors practice social distancing, that you just don't have any for a certain amount of time. And then posting the guidance from the Illinois Department of Public Health and the Illinois Attorney General. There's lots of signage that these agencies have developed. And from an education and training standpoint, if you haven't already done so, you should certainly post these where employees can see them in a prominent place. So this is a handy dandy chart that the IDPH has put out of where we were and where we are. We are, as I said, at phase 4, the revitalization phase of the Restore Illinois plan. As you can tell, 50 gatherings of 50 people or fewer are allowed. Restaurants and bars can reopen. Travelers resuming, childcare and schools are open. So this is all under the guidance of the Illinois Department of Public Health, and face coverings are the norm. How is this enforced in Illinois? In Illinois, under the auspices of under Chicago Department of Business Affairs and Consumer Protection, they are the ones that have been enforced to issue complaints, issue citations and warnings, actually, on the basis of complaints. You know, people are complaining, and these are the most recent statistics from last week. I believe there were 764 complaints received, 59 warnings were issued, and there are monetary fines associated with, you know, employees can complain, vendors can complain, customers can complain. I'm sure in the news you've seen restaurants are getting a lot of, you know, if you see a restaurant not abiding by the 6 feet distance, you know, they're getting called out for it. Most recently is this emergency travel warning that that Chicago has instituted. It's a 14-day mandatory quarantine for travelers coming to Chicago or returning to Chicago if you live in Chicago, from 15 states. These states include Florida, California, Tennessee, Louisiana, Arizona, basically areas where there is a huge spike in numbers. And the travel warning comes with fines. It's up to $7,000 a day if you violate and do not mandatory quarantine yourself when you arrive in Chicago. There's as I understand it, this went into effect actually just on Monday of this week, July 6th. They are educating people by having signage in airports at O'Hare and Midway, on the roadways. it's essentially to make sure that, Illinois has done has done so much to sort of curb this pandemic. And because we're seeing spikes elsewhere, and because travel is resuming, we want to make sure that we don't taint our population with people going to high risk areas and coming back, and then we have to institute restrictions again. So, so this was literally just put out earlier this week. Another way that enforcement is being done is with the Illinois Attorney General's office, where they are conducting random audits of essential businesses' safety protocols. So typically you might think, oh, essential businesses are definitely wanting to go to hospitals and healthcare clinics to see if those protocols are being instituted. But, here's just one example. Law firms and accounting firms, for example, were considered essential businesses under the original order. So presumably, you could get an audit of your practices and safety practices, and they are conducting them. So that's something that I wanted to highlight. OSHA is the Occupational Safety Health Administration. A little bit more about OSHA later, but OSHA puts out signages, posters that are appropriate, that if you have not already obtained them, it would be good to get them and post them. And we'll talk, as I said, a little bit more about OSHA regulations and the obligations of employers, including reporting of any positive COVID cases. The next one is another way that it's being, these safety precautions are being enforced are through the Department of Public Health and also local health departments. Each county has their own health departments, and they have the right to institute investigations. They conduct public health investigations. It's pursuant to a communicable diseases statute. And this is from personal knowledge, because I had a couple of clients in the past couple of months where they, because of the industry they were in, they had more than 2 COVID positive cases. And lo and behold, the county health department contacted them and said, we want to see your data. We want to see you screen. We want to see what your policies are. And they did a complete assessment of the plans that the employer had, and they continue to monitor the incidences of COVID, whether it's been curbed, and if policies are in place to take continued precautionary measures. So this is a very real thing, and it's happening. And so people should be aware of it, and they have every authority to do so. And again, as I said, it's pursuant to statute. And employers have a duty to cooperate and disclose data. You cannot say, well, this is private information, it's confidential information. The statute covers that. It specifically says HIPAA is not a bar, and that confidentiality is, there's no confidentiality attached because the government is doing a public health investigation. So please be mindful of that. So the next is a corollary to the fact that local health departments are doing investigations of workplaces. Is you might ask, well, how do they find out? How they find out is employees report. This is very, it has unnerved a lot of people. It makes people skittish about going back to the office. There's actually guidance. Not only is the Illinois Department of Public Health putting out guidance for employers, but there's actually a poster for employees and staff that was issued on June 26th that basically says, if you have concerns with your workplace, dear employee, if you know of 2 or more employees with COVID at your workplace, you should contact the Attorney General's office or the local health department, and they link the poster to the Attorney General's phone number and email address, and every local health department. You just have to put in your zip code, and then it gives you the local health department that they should contact, so that the local health department will open an investigation. So not only could you have the random inspections by the AG's office, you can certainly have your own employees say, okay, they're not following this guidance and the regulations, and we're going to report you, and you will get, and you will have people follow up. So be mindful of that. So I sort of covered all of that just to say that the regulatory agencies have put out a lot of guidance. My suggestion is follow it. The CDC has it, OSHA has it, the Illinois Department of Public Health has it. It's guidance prepared to prevent workplace exposures. It's really helpful. There is some industry-specific guidance. If you're in the retail industry, for example, there's guidance related to retail. Manufacturing has its own guidelines. There are helpful checklists in terms of, what you should look for and what you should pay attention to. Just a very clear pathway in how to take account of the hazards that may exist in your workplace and the precautions that you can take to prevent them. And a quick note here, right? So this is all quote unquote guidance. It's not law, it's not regulations. And so, and actually there's a 50-page brochure that OSHA puts out about getting back to the workplace. And it specifically says that it's, quote, advisory, that it's only meant to assist employers to provide a healthy and safe workplace. But of course it says, but remember, you have a duty as an employer to provide under the general duty clause of OSHA to provide a health and safe work environment. So they do link, even though this is all quote unquote guidance, they do link it back to the fact that all employers under OSHA have a general duty to provide safe and healthy work environments. And of course, pursuant to the executive order that we're under, you must do this, right? So, so it's guidance that they're helping you, but remember, you've got to do it. One thing that I would urge everybody, if you haven't already done so, it's I believe it's 7 or 8 pages. It's a CDC's interim guidance for businesses and employers. It has a nice checklist. It tells you, it gives again, a roadmap of what to do. And I highly recommend that people read it if they haven't already. One of the things that CDC says and the IDPH is to develop a workplace health and safety plan. If you haven't done this already, it is very important to document what your plan is, what you are going to do it. And what does that include? It definitely includes to do a hazard assessment, to go and figure out what potentially needs to be changed, altered, modified in your workplace so that people can be safe in this situation, and to develop controls to address those hazards that you have assessed. And does this include changing the way people work? Yes. Does it include education and training? Absolutely. You're going to have to tell supervisors how to go about monitoring and enforcing protocols, new protocols at work, and then making sure that employees follow them. Just a quick point here. I've mentioned that regulations have put out guidance. Almost always there is guidance that applies to healthcare and non-healthcare. So because hospitals and healthcare facilities are under their own separate regulations just by the virtue of healthcare. So just be mindful that when you're looking at the guidance, that you're looking at guidance that applies to you. Same thing again, IDPH also has guidelines, as I have touched upon already. There is industry-specific guidelines that IDPH has put out that is very helpful. Again, they do guidelines, they do checklists, and then they also have best practices listed in there that are helpful. But they address things like health and travel and monitoring, changing the physical workspace, staffing and attendance issues. And if I didn't say this before, it's here, but under phase 4, offices can operate at a maximum of 50% of office capacity. So even when we're talking about going back to the workplace, you're not putting everybody back in. So be mindful of that. It's sort of staggered getting back to work. How do you do hazard assessment and control? You identify how and where workers might be exposed. You have to go into your workspace and literally do a walkthrough. I'll tell you my own firm, I was involved in the hazard assessment, and what we did was that we actually hired an infectious disease doctor, an expert to help us, because they know specifically how the coronavirus is transferred And you can read, I mean, it's basically, now they're saying that it's airborne, you know, it doesn't fall to the ground. There's just so much out there that, you know, you might want to seek expert assistance on your walkthrough of your space to say, okay, you know, doctor, what about this? Should we put plexiglass here? Should we remove, you know, if you have an open floor plan, apart from keeping people at 6 feet, should we remove things? So it's more, so you're not running into people. Do you want to put in directional signage so that the flow of traffic in your office is one way? So experts are out there that will help you figure out, if you don't know, what the hazards are in your office. And that's another way of the CDC and IDPH also highlighting certain things in terms of what potentially could be hazards in the office that you should pay attention to. Changing your workspace is, I've been touching about this already, but you know, you might want to, as I just said, you know, change hallway direction. So when you're walking, everybody walks in one area, because there's an issue about how coronavirus is, you know, how the airflow actually has an impact on the virus. Do you need to limit the number of staff even below the threshold capacity that you're allowed to now? Limiting break and lunch rooms. I've already touched upon that about, you know, do you just get rid of that? You know, if you have a water cooler where people are constantly touching it, do you want to get rid of all of those communal things and just say, okay, we can't offer a water anymore? Or, you know, do you just bring in bottled water? Do you get rid of the coffee machine if it's something where people are handling things? Or do you put gloves next to the coffee machine and say, if you're going to pour yourself coffee, make sure you wipe everything down and use gloves? Do you have sanitizer available? Do you want to install plexiglass because people are sitting close enough that you want to make sure you want to have a barrier? So things like that are considerations that you need to take into account. Daily health screenings as well. I'll touch upon this in a slide coming up. But when you go back to the workspace, you know, you might want to consider whether you want people to have their temperature taken, so that and attest to the fact that they're symptom-free of the coronavirus symptoms, so that when they're coming into the office, they're basically saying they are free of they're not symptomatic. There is so much available on the market these days. If you just sort of start looking, you know, apart from, we all know there's so many different masks that are being manufactured now. But aside from that, you know, you can get touchless keys. You know, my own office, we have gotten a little contraption where you don't have to touch elevator buttons, and you don't have to touch door handles. It'll open door handles for you. We've gotten UV light containers that you can put your cell phones and keys to kill germs that everybody has available to them. We have lined door handles to the extent, if you need to use it, with copper lining, because copper lining is shown to have kill the virus. So that's something that you know, you can look into new products that are available. Another thing in terms of configuring the workspace, which I should have said earlier, was just in terms of your receptionist area and even office spaces. You want to remove magazines, and you want to have a clean space. The guidance is that, you know, you should not have a lot of these tchotchkes around and people with, you know, picture frames and all of this stuff that's, you know, means a lot to people, but it's just the guidance says to take all of that stuff away, have a clean workspace and clean desks. And certainly, you know, one idea that a lot of employers are doing is doing a little welcome basket where you give sanitizer, maybe a pair of gloves, a key fob that, you know, is touchless, and Lysol wipes, so they have that, and of course masks if you want to give out the disposable masks. We also have, I don't know if you can see from the camera, but one of the things that we've done is, if you're in the office, and I'm actually in the office today, it was easier to do this in a conference room, is that we give out stickers. So once you come in, and you sign an attestation at my office saying that you are symptom-free and that your temperature is below 100.4, we get stickers. I don't know if you can see, but like today's Wednesday. So then that way you have the comfort level of other people in the office that that if they see you with the sticker on, that you have basically said and attested that you're symptom-free and that your temperature is not 100.4 or over, and that and then you're okay to be in the office. So it's just, it's really, a lot of it is to make employees also comfortable that they are back in the office. Communicate and train. Obviously, I touched upon this before. Supervisors should know the protocols and new policies that are being put in place. Just as an example, I've said this about lunch rooms and break rooms several times. One of the things that you might want to do is limit the number that go there at a time. If you already see 2 people there, you can't have more than 2 people. And of course, that depends upon how big your space is. You might have to train certain employees to sanitize and clean highly used surfaces, so that people go around, and whoever is tasked with that, to make sure that they're cleaning with disinfecting solution and wipes the door handles to the bathroom, for example, or the receptionist's phone. There should be a protocol to say, okay, if someone else is covering, for example, the lunch hour for the receptionist, then there should be, people should be mindful about, okay, there's a new person using the desk area, so make sure you clean. So things like that you should be mindful of. So in terms of back to work, general health issues, again, the guidance says, even at phase 4, if you are able to work from home, you should still work from home. If that's permissible with your employer, and also if you're able to do that. Again, have your face covering when you're within 6 feet of others. Physically distance distance 6 feet, and then you should have employers should provide sanitizer and hand washing capability, so that people are cleaning routinely and consistently. So it's done frequently. I just want to touch upon the fact that there are some employers where currently, because of the situation, if you're not full staffed and if you're not required to go back to work, they're saying it's voluntary attendance. And by that, the policy is stay at home. You don't need to come in. As an employment lawyer, I'll tell you, that's fine to do, but just be mindful that you're not modifying the at-will relationship, where you can still terminate that employee for any reason or no reason at all. You don't want people to be comfortable in the fact that, oh, they can stay at home, it's voluntary, not work, and then you can't terminate them. So avoid using language that sort of modifies that relationship, or that they're never going to be disciplined because they're not coming to work and it's under this voluntary attendance program. Health monitoring, I was touching upon this earlier, the temperature screening, and then the questionnaire about symptoms. So again, we've instituted this at my own firm here, that we have anybody who's coming into the office sign an attestation saying that there's a list of symptoms that are associated with the coronavirus that we put, and then the employee just simply has to say that they are not suffering from those symptoms, and that their temperature, and then they took their temperature. So that's essentially what I mean on this slide by questionnaire. I would advise not to take temperatures and record the information, because then it becomes a medical record, and then you have to keep that information separately. And even though it's not technically subject to HIPAA concerns, it is subject to privacy under relevant laws. And so, I think you can have an employee attest to the fact that their temperature is not over a certain degree, but certainly don't have a log of their running temperature for employees. It's not on here, but I just want to touch upon it because people have been asking me about it in my line of work, is about what about waivers, Samera? What about to limit liability? Usually waivers, unless they're just pretty much unenforceable. Unless it's gross negligence, it's not going to prevent you from getting an enforcement action. Waivers are nice to think about to limit liability, but in most courts, I think that they would be unenforceable. And I really think that, this is about keeping you and your employees safe. So instead of thinking about limiting liability, just think about maintaining a safe environment. That's basically been my advice, and it's my advice to you too, is, you can think about all of the legal avenues that are out there. But this is truly about, following the guidance and making sure people are comfortable to return to work. And so, of course, there's also, again, the EEOC guidance out there with reference. And I wanted to touch upon a couple of things with the EEOC that employers should be mindful of, because you could be subject to, discrimination issues. Again, with the American with Disabilities Act, the EEOC just recently put out and clarified guidance a few weeks ago that basically says employees must still tell employers that they need reasonable accommodation for a disability. So, again, employers are not mind readers, so nothing in the pandemic has changed that obligation of the employee to tell you, employer, that, you know what, I need an accommodation because I have a disability. If they don't tell you and you don't know, then you're off the hook, essentially. Recent guidance on undue hardship. Given the pandemic has affected the bottom line for businesses and economically, if an accommodation truly becomes expensive and there's no other way to do it, there's no other way to accommodate an employee, then, that's okay to say, okay, it's an undue hardship. We cannot do that. We don't have the money to do that, for example. But again, be careful, because cost is a consideration. You just can't outright reject a potential accommodation just because it costs money. You have to look at it to see how it affects, would it cost too much proportionally to what you have right now coming in. Employers cannot bar employees because of underlying medical conditions. So this is the issue where you can't be, even if you have a benevolent desire to say, oh my God, so-and-so just went through cancer therapy last year, I really don't want them coming into the office. You can't do that. Unless there's under the statute, unless there's a direct threat, then, for example, if the person is undergoing chemotherapy now, for example, then you don't want them coming in. But you can't sort of make judgments on your own and bar employees. It would be unlawful under the ADA. Similarly, again, you might have a benevolent motive to sort of say, oh, so-and-so is, 65 years old. I really just don't want them coming here into the office. Don't come into the office. That's age discrimination. You can't do that. So even though you're thinking that you're acting out of the goodness of your heart, you can't do that. That's age discrimination. So be mindful of those things. Just a quick blurb on harassment, a line on harassment. Just remember that harassment can occur remotely. People forget that all the time. They think, oh, we're not in the office, this isn't going to happen. But people, text mails, emails, just be mindful of that. Because we're working on new policies, because we're revamping older policies, remember the existing policies that you are subject to as an employer, and be mindful of the fact that you have to enforce everything that was before the pandemic. So, and that could be a real concern. I'll just leave it at that. Just be mindful that, it can occur remotely. People don't have to be physically in the office for harassment to occur. And then, of course, the EEOC guidance has put out, temperature taking. Initially in March and April, a lot of employers, certainly without the guidance, were wondering if it was okay to do. Would it be collecting medical information and the like? But the EEOC has absolutely come out and said temperature test taking is okay to do. Testing employees for, telling them to go get COVID tests is also okay, as long as you're doing this with CDC guidelines. the employer will be acting consistent with the ADA. So this is a really huge point that the EEOC has said. As long as you're implementing guidelines that are consistent with the CDC, you are acting you're acting consistently with the laws that you have to follow. Okay, so I said I would touch on OSHA too. Again, the general duty clause that I mentioned earlier, employers are required to provide a workplace free from hazards. And again, you have to examine your workplace conditions to make sure that they conform. And that you provide a workplace that's free from serious and recognized hazards. These are some of the general duties that the OSHA Act lists, that what you have to do. Make sure that employees have safe tools and equipment. Here the applicable thing might be, a mask. Establish or update operating procedures. You have to do this. There are reporting obligations, which I'll touch upon, and then whistleblower protection. If an employee, rats you out, you can't take action. There are just because they have reported you. There's protection for that. So this is the reporting obligation. The guidance flip-flopped on this over the past couple of months, so that's why I just wanted to touch upon it. But typically, if you have work-related injuries and illnesses, they need to be recorded on what's called a 300 log. And what OSHA says now, and this is what's come out now in the guidance, is that employers in all industries should determine whether employees' COVID-19 illness are work-related. And it's basically, it's a reasonable standard that you make a determination whether, after doing an investigation, whether an employee's illness, a COVID illness, was obtained from work or not. So this is just not hospitals anymore. This is all employees have to do this analysis to make sure that the illness was acquired elsewhere. And then, of course, you don't need to record it and you don't need to report it if, after a reasonable and good faith inquiry, the employer cannot determine whether it's more likely than not that the exposure was in the workplace. So if you come, if you have a reasonable determination in your mind after an investigation that the exposure was likely not in the workplace, then you don't have to report. But please do the analysis because you're obligated to do so. Okay, and then what if an employee has COVID-19? So generally employers, again, this is non-healthcare, don't have a duty to report, to a public health agency. But you do need to notify your staff and coworkers. You should not identify the person. That's subject to confidentiality. You should close for cleaning, and you should contact trace and isolate the person who has COVID and have them monitor their symptoms. When you contact trace, there's this thing called a 61548 review. What is a 61548 review? You should do this. You should ask the infected employee to identify all individuals that they work closely with, meaning within 6 feet, for a prolonged period, which is 15 minutes, from the 48-hour period before the onset of symptoms. So somebody tells you, I'm positive today, then you need to sit them down and say, okay, from Monday to today, who were you in contact with that was near you within 6 feet for more than 15 minutes? And then you need to tell those people, and those people have to isolate and monitor their symptoms. And you have to isolate for 14 days pursuant to the guidance. And again, you might think like, oh, I don't want to tell everybody because it's just going to make everybody nervous. You have to. They're under OSHA's general duty clause. It's a violation if you don't tell your staff. So please, if you have an employee who gets it, there and there's messaging that's done, so that you can create and post. So please be aware of that if you are not already. Leaves of absence are another area which that should be considered here. This is one of the topics that I could literally spend an hour on. I'm just going to allot a slide for you here just to highlight it. I'm sure everybody's aware of it if you're in an HR or employment arena, but the Families First Coronavirus Response Act was enacted. It includes emergency paid leave and an emergency family medical leave. It applies to 500 or employers with 500 or less employees, fewer than 500, not 500. Employees that have less than 50 are subject to some exemptions. It is only until December 31st. The effective date was April 1, is when it was effective, until December 31. It basically guarantees 2 weeks paid leave that can be done intermittently for a host of experiences that employees may be dealing with COVID. So if they have it, if they're taking care of somebody that has it, et cetera. And depending upon the reason, you're either fully covered or 2/3 of your pay. And this is all, employers get all of this back through tax credits, whatever they have paid out under the emergency paid leave and then the emergency family medical leave. The posting requirement, if you have not already done so and you are HR, if you're listening in, if you are in an HR or an employer, there was a poster that was released a few weeks after the law went into effect that requires you to post this law and the leaves that it mandates and the reasons. It was generated by the Wage and Hour Division of the Department of Labor. It's in multiple languages now. And if you haven't done already, please post it. If you have a workforce that is remote, remember that obligation can be done by emailing it or putting it under an intranet site where employees can go to. So some common questions, and then we'll be wrapping up essentially. So in my line of work, these are some of the questions that I've been seeing. So I thought, okay, let's just put it out here so that maybe you have these same questions. Can an employee refuse to come to work once business operations resume? They don't want to come back, but they're too scared. Only if they believe they are in, quote, imminent danger, which is defined as threat of death or serious physical harm. Most work conditions do not meet the elements required for an employee to refuse to come to work. If employers follow the CDC and OSHA guidance to ensure that employees are not in imminent danger, most employees cannot refuse to come to work. One example that I can give you is, requiring an employee at a hospital to work without personal protective equipment. That would be imminent danger, which is placing the employee in a threat of death or physical harm. That employee can say, you're not giving me the correct, I refuse to come to work. That may meet the threshold, and again, I say may, that may meet the threshold, but there's very little that does meet the elements. So most employees will not be able to refuse to come to work. Next question, an employee wants to continue to work remotely, even though the employer wants to call people back in. Remote employment was kind of a benefit because you can't go back. The answer to this is, again, as I say, even though you have a preference, you can refuse remote work. You can say, nope, sorry, that was done. Now you need to come in. But just be mindful again that if it's being done as an accommodation under the ADA, then you should continue to allow them to do the remote work. But again, that would require you to engage in what's known the interactive process to determine whether, because of a disability, the employee needs to continue to be at work, continue to be working remotely. But by and large, preference is just not enough if you are going to have people coming back in. Can employers require employees to notify the company that they have been exposed or tested positive? I would say yes, absolutely. You should. Not only do you as an employer have an obligation to tell your staff that if there's somebody COVID positive, but that employee should not be hiding anything. So if they have been exposed or if they have tested positive, you should absolutely require employees to notify their supervisor or some other person, and they should not report to work. They should stay at home until they're symptom-free. Just a point here, people could say, oh, you were exposed. The guidance says to stay at home for 14 days. Somebody could say, oh, I just took it on the 10th day, maybe somebody will say, oh, I took my I took a COVID test. It came back negative. Can I come into work? Absolutely not, because if you were exposed, the incubation period is 14 days, and so there's still, you know, just because you were negative on the 10th day doesn't mean that you may not be, you know, for the remaining days. So make sure that they quarantine themselves for 14 days. But absolutely, employees should be required to tell employers. Paying for things. Do employers need to pay for sanitizer and masks? And the answer to that is yes. If you require face coverings, you should pay for them. If you, you know, sanitizer too, you should provide all of these things. And I had a note in here for myself to talk about just transportation. A lot of people might be skittish coming back because they don't want to, you know, they don't want to use the CTA or the Metra. You know, and in fact, the CTA, the last time I checked a couple days ago, the websites still say, you know, find alternative methods of transportation. We're still using the CTA to transport essential workers. So, but every day they're getting better in terms of having more people use the transportation system. But again, this is, again, as I said, about keeping employees, you know, comfortable. So I do know of employers that I've counseled where they're giving stipends, for example, for transportation costs, you know, defraying parking costs, or at least subsidizing them. So these are all things that, as an employer, even though they might not be mandated or required, you know, you might want to consider if you want to have a workforce in the office, and to, you know, to give temporary benefits like that. That's certainly a consideration. Question about if an employee requests reasonable accommodations because they live with somebody who is vulnerable. I live with my grandfather and I just don't, or grandmother, and I just don't want to go outside of the office and work, because what if I bring it back to them, and I'm just afraid of transmitting, you know, please, can I work from home? The EEOC says no, basically says that that reasonable accommodation does not extend to avoid exposure to a vulnerable family member. So you don't have to accommodate in that instance, because it's simply avoiding exposing a vulnerable family member. So why is all of this important? Of course, is because of the potential liability that you as an employer may face, not only from government enforcement actions that we've discussed, but of course cases that can be filed. There was literally one COVID-related case that was filed in January in Texas, and it was a labor case. There are 122 cases now in June, or as of June. They are only increasing. The most common ones are those involving discrimination and those involving working from home, remote work issues. I think just because of the issues that are surrounded, that the numbers will rise. So I just wanted to toss out the statistics out there. It's just the reason why we should be concerned, aside, of course, from of keeping our employees safe. The areas of potential liability are these, you know, citations, the local health department complaints that we discussed, discrimination complaints, whistleblower complaints, workers' comp. Again, that's a specific area of the law if an injury arrived outside, you know, related to work. And then, of course, breach of contract too, I put in there, because sometimes employment agreements, I mean, if you're going to terminate because of lack of work, you might have a breach of contract claims. So these are, I just wanted to toss out areas that that employers are susceptible to get claims. And it's not just employees. You can get them from non-employees, such as customers and vendors, and visitors can all make claims or file complaints. So, you know, this might be overwhelming, but one of the best things I think is to be prepared to show that you followed guidelines, the CDC guidelines, the guidance that we've talked about today, to generally reduce transmission, because that's, at the end of the day, the best proof that an employer has to show that an employer acted reasonably. And again, I would not be an employment lawyer if I did not end this by saying, document everything. document all the efforts that you've done, document all the training that you're preparing, the posting of the signs that you've put up, the procedures that you've changed, the policies that you've amended, the equipment that you've purchased to put people in, make people safe, the processes that you've put in place, the protocols that you've created, the training materials that you're using to let employees know that these are the things that you should do. Document all of that, because it'll go a long way to show that you're really taking your responsibility of keeping employees safe seriously. So with that, I'm happy to answer any questions. And I know I went through a lot. I don't know how our time situation is, but there's my contact information. I'm happy to engage by phone or email with anybody who has questions. I prepare a lot of these forms and processes. And so if you have questions about that, I'm happy to discuss those as well. So with that, I will stop sharing my screen. Okay.
Samera, thank you very much. That was very thorough, but I think the questions at the end were welcome. I know that anticipated a few questions that we had on our end. Hi everyone, I'm Molly. I'm the event manager at FACT Chicago. I know we have a couple minutes left, so we don't have much time, but as Samera said, she put her contact info up briefly. The message I just shared with you all is that we'll send out a follow-up email with Samera's contact info, how to get in touch, along with today's presentation, and then a copy of the video that we will also put up on our website's archives and on our YouTube channel by about lunchtime tomorrow. If anyone has questions they want to ask out loud, you can now unmute yourself and then put your webcam on if you're comfortable to go ahead and ask Samera. We have a couple minutes.
And I just want to say about the question and answers too. You know, again, I would be only giving general guidance. So if there are really specific issues, I would prefer that people email me separately, because what I would be most comfortable is sort of directing people to where they can get more information if I can't answer your question fully. So with that caveat.
That makes perfect sense. Looks like no one has any questions via the chat. It doesn't seem like anyone has any they want to ask out loud. So what we can do, Andrea, did you have any questions?
No, I was just gonna, I was just getting ready to see if anybody did, but we definitely still have a couple minutes, so feel free. We don't have anything in the chat either, I don't think.
No, yeah. It's a lot to process for sure, so.
It is a lot to process, and as I said, that's why I want it to be as comprehensive as possible, just because if these are considerations that people are taking into account, you know, there's a lot to look into, so you can only sort of do I want to touch upon as much as possible, so.
And maybe the questions are very specific, in which case we'll make sure that everybody has your contact information and can follow up afterwards.
Sure.
Well, with that, Molly, feel free to wrap up.
Great, thanks. And yeah, so Andrea and I are both at the FACC. We're here for questions as well. Obviously, Samera will be any legal questions, but we're here if you have questions on our upcoming events. A quick push for our next upcoming event is our first ever virtual gala, which we're really excited about. Obviously, you can be in any state whatsoever, so you can pass this on to friends, family, colleagues. And then if you're not available July 22nd, the day of the gala, you can still go ahead and bid as of yesterday, actually, on our online auction. And then we also have raffle tickets for sale as well. All those details are up on our nice shiny platform, and I put the link in the chat, and it'll also be in the email. Again, it's our next upcoming event, so we have a brief pause for a couple weeks, and then following the gala, we'll probably have one more webinar for the summer, take a brief break, and we'll be back in the fall with our complete programming. But again, we'll have all our contact info and a summary of that in the email that I'll send out this morning. Thank you. Thanks, Samera, as well.
Yeah,
thank you, everyone.
Thanks, Samera. It's good to see you, and thank you to everybody who was here this morning. Bye.
Thanks. Bye-bye.
Be safe. Bye.